these obligations, who actually has rights to whatever you're developing. Take, for instance, a software developer who may be assisting you in writing some code. Maybe in a personal contract you entered into with that individual. There's ways to correct all these things, like you can assign them over to the corporation, but to the extent that you're able to and you have the corporation set up already, all those contracts, all those obligations are encouraged to be directly and clearly demarcated as being obligations of the company. So let's talk about doing an operating name or business name. Sometimes you incorporate a company and you got 1, 2, 3, 4 Ontario Inc. or something like that, and you don't really like that name. You don't really want to be known as that name. You want to be known as whatever your fantastic operating name is. Well, you can do that. You can register a business name registration, and when you go out and conduct and carry on business, you can do so using that corporate name. And there's ways that, notwithstanding you're using that on, for operating, for selling yourself to the public or for selling your goods and services, when you're still entering into formal legal documents, you use the legal name. So 1, 2, 3 Ontario Inc. And you can always identify it as doing business as whatever your special name is. So things like that. Corporations, it's not a natural person. It just doesn't show up at the door. It is literally a body. It's a creature of statute. It's a creature of its sort of historical documents. So it's really important to keep good records. So anything you're doing on behalf of the corporation or with respect to the corporation should be documented, and should be documented in the form of like written records. These take the form in like corporate law, we call them resolutions or minutes or things like that. But essentially what you're doing is when the corporation takes actions, it needs to do so, needs to be documented in writing in a written form, whether that's in some internal corporate document or in some agreement that you have with some other party. So it's always best to reduce any sort of your contractual dealings with third parties or anyone else to writing. And it's always important when you're dealing with sort of bigger liabilities that you seek appropriate legal counsel helping sort of negotiate and draft those. Sometimes people talk about entering into options or issuing equity, or if you help me out, I'll give you a piece of my company. Those conversations, those discussions can lead to very sort of maybe unexpected outcomes. And it's something that you should really sort of take seriously and sort of understand what you're getting into, because ultimately that's what's going to affect your interest in the corporation, your ability to control it, your ownership interest and all that as well. We're going to talk about this later. I'm sure Tony will touch on it too. Every single corporation has intellectual property, whether you know it or not. Your company, you have some intellectual property associated with your business. If that's the business idea, if it's a trade name, if it's a registered piece of intellectual property, such as a trademark or a patent, you have it. And so part of it is making sure that we talked about earlier, that a corporation is the proper owner of that. So you can assign intellectual property to your corporation. One of the things we do when we set up a corporation, we help founders, we help ensure the property assignments are in place so that there's a good documented record of the corporation receiving and or owning this intellectual property. And any agreement that you may have as an officer or as an employee of the agreement should set out too that anything you develop, make, create with respect to this business is the corporation's property. It's not your property. So there's no overlap, no confusion as to who actually retains any ownership rights or intellectual property rights with respect to this. It may seem like a kind of trivial thing, but I can tell you every single investor at the end of the day is when they look at your company, when they look at those documents and all that stuff that you put into it, they're going to say, where are the assignments? How do I know the corporation owns what it says? How do I know all your employees don't have any residual rights in sort of the intellectual property you've created or done? So these things become very important down the road, especially when you start talking to investors or you start talking to potential people maybe looking to acquire a business as well. So we help with all that. A lot of your documents, it might seem like a kind of simple, trivial thing. It's really important that they include those proper assignments, especially to ensure that when you're contracting with someone, you're getting the full benefit of all that. With intellectual property, it's good to have a business plan. It's a lot of tech companies, a lot of early stage companies now, this is their core asset, this is their core value proposition is intellectual property, and understand how to protect that becomes paramount and key. There's things that you can do in terms of negotiating in commercial dealings with confidentiality, non-disclosure agreements. They become very, very important. So there's, often what you're doing is when you're negotiating contract with third parties, you're going to bring something to the table. They may bring something to the table trying to help you out. You may need to share or disclose certain information in getting that done. If that's new code, if that's a new product, if that's a new application, if it's a new solution to a problem, you may need to partner or work with someone else who's going to help you provide solutions. Chances are you're sharing intellectual property when you're doing that. And to ensure that you are retaining your interest in it and you're protecting it so someone's not going to be able to walk away tomorrow and take your $1 million idea and start using it or competing with you, you should always be sort of looking at whether or not you need to enter into a sort of confidentiality agreement or non-disclosure agreement with that individual. It becomes kind of key. We talked about assignments, acknowledgements, confirmations, things like that. Employees, independent contractors, anyone who's providing services for and on behalf of your corporation or providing services to your corporation, including yourselves, you think about an assignment, think about any residual intellectual moral rights they may have in that intellectual property. And again, it's always good to contact professionals here. Talked about confidentiality, non-disclosure agreements. Very customary. Very few people doing commercial transactions have a problem with entering into these. Some investments maybe a little more so, but again, it's part of the trade-off in terms of doing any sort of deal. Yeah.
So I'm Aaron. I'm a colleague of Graham's here. I'm a corporate lawyer as well. And one thing we see all the time with former startups that become successful companies, investors are coming in, or they're going to sell the business, and those are the 2 points in time at which people start looking at your documentation. No one really seems to care until then sometimes. Like, there are things that matter and you can have lots of problems, but generally, life goes well. You hired an employee, they created some code, they left, no one complained. You hired a contractor, maybe they're off Fiverr, maybe they're in Canada, who knows, no one really complained, there were no problems. An investor comes in and says, great, you're a tech company, really what you have is IP, that's really what you have. Please show me that you own all the stuff you think you own. And suddenly the company's going, well actually, we have no documentation, I've paid some people, and then the lawyer starts saying stuff like, oh well, were they employees or independent contractors? Because it turns out the default position from IP is actually different if they're an employee or a contractor. But if they're an employee, you got to pay them more, like there's certain statutory rights. All that to say, these things become really important when it comes to raising money or eventually exiting and selling a business. And you end up taking on a lot more risk or potentially having issues if you haven't documented properly.
And ultimately, it sounds silly, it costs more. Like, there's a little pain up front and having, working with professionals to kind of properly set these things up. But what we do, and with our expertise, we're always trying to ensure that you can put your best foot forward when you meet with investors or meet with potential inquirers, and you're checking all the boxes. So that when you're going through that due diligence process where investors are coming on board or looking at a company, you can check the box and you can say, here's the assignment, or here it's in the independent contractor we signed with that individual. There's a clear assignment of any and all inventions created or associated with this work. All that sort of stuff. So we help to protect you and do that.
So during the process of where an investor asks you for information, do you have any information on what are the best data rooms to use when you're disclosing that information?
So data room is just simply like the sharing of information, and there's sometimes investors have their particular preferences as to what they want to see shared. We work with all different types, with third-party commercial ones that are very secure to drop box to like anything in the sun. Some people just exchange it vis-a-vis emails now, as long as they're subject to proper confidentiality agreements. When you're starting to do a deep dive like that, you're probably pretty far along in terms of the in terms of the discussion negotiations. You may even have a term sheet signed at that point where you're trying to share sort of core key documents. And at that point, it depends on the size of the deal and size of the transaction and how many documents there are and how the best way to sort of handle that process is. Yeah.
I was wondering just if you could maybe group the subsequent questions, just repeat questions so we can make sure that everybody hears it.
Sure, to the extent I'm able, absolutely, no problem. Balance sheet. So the other thing that's really great about corporations is they allow you to easily divvy up and divide economic rights entitlements. So a share, or the corporations have shares for the most part. We'll stick with limited liability corporations and their share structure. They have shares. You buy shares or you get issued shares. Those shares entitle you to benefits of the corporation. They give you certain rights and privileges, like the right to vote, right to receive dividends if it has one declared by the board. They give you the rights to assets of the corporation on dissolution. Some shares might give you additional rights or preference rights or preferred rights. And so all this information, all this stuff is baked into the articles of the corporation, and it's set out in sort of the constating documents of the corporation. So these become very important, and very important later on when you're structuring investment. So typically for like an early stage company, you might have one class of shares or two classes of shares, and they're probably pretty vanilla and pretty plain, and that's absolutely fine, and you don't need anything more complicated. When you start to talk to sophisticated investors, they might come on board and they might say, listen, I'm giving you a significant investment, and I want to see a return on my investment. So I want what something might call like a liquidation preference. In other words, I'm putting my money in last, I want my money out first. And that's something that gets negotiated and gets worked out. Those are usually things that get worked out on term sheets when you're doing sort of larger financing or equity raises for your corporation or other types of things. But the advantage of equity is that you're essentially, they're buying into the company, so they're buying a piece of it. They're getting an entitlement as a shareholder to participate in the election of the directors and the function of at least like higher level, maybe conversations or discussions about sort of fundamental changes of the corporation. They're given rights as well. So it comes with a double-edged sword. You now have like a bad partner essentially when you have a new shareholder. And it's a long-term, maybe even permanent arrangement unless you've got some right to take away their shares. But it's good because you can also really easily set out what those rights and entitlements look like and what those people are entitled to in terms of voting rights, information rights, and other things like that through various agreements. So disadvantage, we talked about a little bit, loss of control, share dilution. You're giving up a piece of the equity of the company. Shareholder voting rights, they have the right to nominate directors. Part of what we do when we structure corporations, we help to work with founder groups and investor groups to ensure that they get what they bargained for and help to protect their rights. So as a founder, if we're ever helping act for a founder, we help set it up in such a way that they know what they're walking into when they get potential investors or new people coming on board. Whether that's a shareholder owning 10%, whether that's a partner owning 45% or 50%, to understand sort of what that looks like and understanding what the potentials for conflicts are and advising on it, right? All of a sudden you hit a threshold of over 66 2/3 and you can't take any fundamental action anymore you could have taken previously in some very basic corporate law. It is somewhat of a demanding process. It takes a while to sort of maybe understand the nuances of it, but that's why there's, again, professionals here to help. So this is, typically what people think of like a shareholders meeting, right? Or maybe there's a board of directors sit around in the high back chairs. All the shareholders show up and they now got to say at the table, and they can kick these people off maybe, or they can stop a major transaction because they don't think it's in the best interest of the corporation, or you've triggered something, they got dissent rights, and now they got to pay them out in liquidity, things like that. So it becomes, you open up kind of, you really get into bed or have bedfellows with new shareholders as they come on board. Traditional types of equity, a lot of these things we talked about, there's common shares, preferred shares. Shares are, can be any sort of things you kind of want them to be to a certain extent with respect to the rights and privileges you can assign to them. You can grant rights to acquire equity, so there's rights in the forms of warrants or options, which is essentially a contractual right to purchase or acquire equity from the company. Safes are something I don't know if you guys heard of. It's another form of equity. It's basically a simple agreement for future equity. There's usually a condition on which a money paid for that safe will convert or turn into equity at a steep discount. It's created out of the, I've worked with a couple of them, created out of Silicon Valley, Y Combinator, things like that. Simple agreement for future equity, same thing. It's kind of a convertible note, which I don't know if you're familiar with, which is a debt obligation, which again will convert on certain milestones. We do a lot of these types of financings. This stuff is usually what you're talking about when you're starting to talk about maybe a seed financing round with some institutional investors who can't really pick a valuation, or they don't want to shortchange you, and maybe you guys can't agree on sort of the valuation. So what you're going to do essentially is defer that valuation point to another larger investment round when you're going to see Series A money come on board. Steps to equity financing. So, you talk to people, friends and family, other co-founders, maybe do some raise through some people some strategics maybe who see value proposition in what you're doing and the ability of partnership early on. And then kind of you can come in, we talked about valuation issues briefly, but then you can kind of come on board to sort of your larger seed financing rounds, which can sometimes take the form of convertible notes. Sometimes they take the form of like a seed pref share, which may be like a 1x liquidation preference. Essentially, again, they're going to get their money out before anyone else does. If there is a sort of liquidity event or if the corporation's unable to sort of carry on. Equity financing roadmap, you often get a term sheet for this. So for an early stage company, you set up, you're incorporated, you're doing well, you're kind of checking all the boxes, you're getting some interest. You realized on your business plan you need $500,000 to carry on your current operations in the next year. So you got to go out there and find funding. You got to find someone else to believe in you who's going to invest in you. So you'd start talking with them. You come up with a plan. Maybe it's a term sheet. They're going to buy in for 20% of your company and give you $500,000. What does that look like? What are their rights going to look like? Do they have a seat at the board of directors? Do they have certain rights in terms of maybe leading subsequent investment rounds, things like that? It becomes heavily negotiated at this point, and it's always best to do this with experienced counsel because you can inevitably end up giving up way too much or sort of losing control of the process and not even realizing it. Shareholder rights. So there's rights that attach to the shares themselves. You can also get rights vis-a-vis a shareholders agreement or other agreements amongst your shareholders. And in Canada, we have this concept of unanimous shareholders agreements. It's somewhat foreign to the United States. With a unanimous shareholders agreement, which is an agreement signed by all the shareholders in the corporation, you as shareholders can restrict the powers of the directors to manage the affairs of the company. When you wear your director hats, you basically manage the company and you're responsible for its operations. Shareholders elect the directors and then they kind of say goodbye and say, please take a good care of my investment. I want to see a nice return on this. Directors are responsible for doing everything else. All right? So with a shareholders agreement, you can say, that's great, directors, I trust you to handle all the matters except for these core fundamental matters of which this small group or this group of investors needs to give a final veto or blessing to. or sorry, needs to give a blessing to. So shareholder rights can be put into a shareholders agreement. Rights between the classes of shares can be divvied up. So again, we talked about some preference shares, maybe having liquidation preference rights, having special voting rights, having, you can do a bunch of different like liquidation preferences, redemption rights, things like that. Those are often more sophisticated sort of discussions you'd have with potential investors coming on board. 5. Statutory protection for shareholders. So you have, again, when you're bringing on investors, it's important to realize what this means and what this entails. And the statutes, the Business Corporations Act, so either Ontario or the Canada Business Corporations Act, has specific rights in there that they grant to and forward to shareholders so that, when there is a dispute, when things aren't maybe going hunky-dory, that they have rights. So they have rights to be, paid fair value for their shares. You can't kind of run roughshod over them. And it's really important to understand these rights and the impact they can have in your business. And so one of the most important things you can do, we talked about, is setting up that shareholders agreement so that you can ensure you can control the process and you know what you're getting into down the road. And some of those things can be approval rights. You can do things with what's called voting trust so that you have the votes at the end of the day to carry matters that may otherwise require shareholder consent and approval, and they don't hold up in the process. Yeah.
So I know this is like briefing, but like I want to know exactly what the difference of term sheets and of investments is from Canadian investors and U.S. investors. I know there's been some like coffee stories that I've heard from companies where they say our U.S. investors like use this for some tax evasion kind of stuff. So there's a lot of stuff going on that I think would be like if you have any experience.
So you have to look at it on an issue. So the question there was with respect to whether or not U.S. investors may have sort of a different motive or incentive in coming into Canada, I think, and whether or not they maybe use Canadian corporations. I don't think that's true. There's a lot of capital flowing north. Most of the clients I act for are actually U.S. venture capital funds and investment funds, PE funds, and institutional investors, and strategic arms of large multinational corporations. And they're really wanting to buy into the company, and they really want to buy into the belief. Some of them are strategic, and what they really want to see is a long-term investment on this technology, and it playing out more so in terms of a practical application, where some of the pure, venture capital funds, PE funds are there to see an economic return and really want to see you guys hit it out of the park and get a 10x on their investment. And it's a very different sort of game. What they're playing when they do the term sheets is they're essentially bargaining for that, and they're trying to set up. When they invest, and this isn't really a conversation about investors, they're investing in you as management team, in your business, and in their ability to see an exit or see success on what their goals are. And those things are all factor into a matrix and equation that they do, and they need to go to with their investment committees make an ultimate decision on it. But what those terms of the investment are what's really important to you, because it may be whether or not you lose control of the process, you can contain control of the process, how much of the company you're giving up, what those rights look like, all that sort of stuff. So there's that. Talked a little bit about a shareholders agreement. Why enter into a shareholders agreement? It provides certainty. You can control the day. So again, think about a minority shareholder doesn't want to sell his or her shares. You want to sell your company. You got Microsoft knocking on the door, going to give you $80 million, $100 million. All of a sudden, one shareholder says, I'm not selling. I have 10% of the company. You don't have a drag, which is a right to force that shareholder to sell. What does that shareholder do? Are they like blackmail? Like, that's not right. And in what world does that make any sense, right? So you put these agreements in place so that you understand what can happen and how you can control liquidity events, how you can control exits, how you can structure further investment rounds, and it becomes very important. Also very important if you want to sell your shares. So if you're a founder and one of your other founders, you're thinking about in small terms, wants to sell his or her shares to maybe a friend, do you have a right to buy those shares first? Can you veto or block that person from selling his or her shares? Like you don't want to. You were working with this one person as a founder, and you like what they're doing, and you don't have a shareholders agreement. Maybe they control the board, or maybe you don't have control of the board, and everyone else thinks it's okay, and you don't. I mean, these are things that we help out and help you work through, and that it can easily and readily be dealt with in a shareholders agreement. And why it becomes very important for early stage companies. The most important document you will have when you're starting out as a founder, when you're starting to organize a company from the get-go, is your shareholders agreement. Use and address multiple situations. Dispute resolution, non-resident shareholders, maintain CCPC status. There's all sorts of things you can do with it. So it becomes really, really, really important. Do you guys have any questions? Yeah.
I hear a lot about convertible debt.
Yeah.
How does it work?
So I specialize in convertible debt. So convertible debt is essentially, it's a loan that you agree to certain terms at which or upon which that debt may, either at the election or option of the holder, or on a forced, or will auto convert, like on a forced event happening, convert into equity. And so essentially what someone's doing now, they say, look, I'll give you a loan for $1 million.
Give away any share.
So you're effectively, you're getting a loan, you have a debt obligation to repay that person, and they may be getting a coupon, which is an interest rate. So you say, look, I'll give you a loan for $1 million at 5% interest for 2 years. If within that 2-year period you complete what we would define to be a qualified financing or an equity event milestone or whatever it might be, which would be a negotiated term, which would say, listen, if you go and raise $3 million of gross proceeds from the sale of your next equity securities, you issue pref shares, you issue common shares, you issue equity securities, and you receive more than $3 million, then that debt obligation auto converts into that financing round at usually a discount. Because what they're essentially doing is saying, look, I gave you a loan, I gave it to you now, I gave it to you early, and I believed in you and I helped you get to that financing round, and I want to convert that amount at like a 15% discount, 10% discount, whatever it might be on the next financing. Essentially the reason why you do it often is because they want to see the investor wants to see other commitment, wants to see someone else step up to the plate and believe in what you're doing, and they also may not be able to agree on valuation. So you'll wait to have someone else fix that valuation point for you. It's very common. It's a very common sort of tool for early stage companies to use in financing rounds.
Okay, thank you.
Yeah.
Just a quick question. So for the agreement, if I set up the agreement according to the circumstances that we have today, and then down the road, if things change,
Yep.
I want to change the agreement, how easy it is to change the agreement? Or can I make an amendment to it?
So when you say agreement, do you mean a shareholders agreement or do you mean the articles of the corporation? Like,
Business structure and the shareholder.
okay, so business structure is usually a corporation, and if you're talking about fundamental changes from the articles, you can usually do things you can file what's called articles amendments to change all those share classes. You typically need 66 2/3 of the votes, or you need a special majority to do that. Often when you're changing them up, you're going to be changing up the rights and privileges that are going to affect people negatively, and that's why you need that. And you're also going to give people the ability to get out or dissent on those things. So you can do it with 2/3. There's other things you can do to basically curtail that. It depends on what your financing rounds looks like. So you're always thinking as an early stage company, you need to be thinking 6 months down the road, 1 financing down the road, 2 financing down the road. What is this cap table? What does my ownership interest in this company look like? And who are my partners in this, and what are they doing? Ultimately, you can change the shareholders agreements in a contract and an agreement, and you'll often set thresholds in there for what's going to constitute a sufficient threshold to amend that agreement, whether it's 66 2/3, whether it's 75%, whether it's 100%. That's something you can set in the agreement, and then it becomes a contract. And as long as you're not doing any amendment that's going to unfairly prejudice one particular group of shareholders or shareholders, typically that the courts have ruled is that you don't need, the people can, at least in the context of unanimous shareholders agreements, pre-approve the fact that will be binding on them, whatever that 66 or 75% agree to. So you can always forward looking. If there's particular provisions you want to put in there, like you want to contemplate maybe having additional directors come on board or increasing the size of the board and giving nomination rights to various investing parties, you can carve out and say, look, we only need 51% of the shareholders to approve a change in the number of directors, and that'll carry the day, with respect to the shareholders agreement. So there's things like that we do when we're helping early stage companies and we're helping them set up their shareholders agreement. We're always thinking, what are you doing in a year? What are you doing in 2 years? What does your next investment round look like? Ensuring you can control that process. Yeah.
If a company's liabilities exceed their assets and they want to repurchase shares from a shareholder,
Yeah.
how can they do that?
Well, you have to, subject to the agreement, and the shareholders sometimes will have an offering, and the corporation can go on and offer to its shareholders, look, like we want to buy up shares, so if you want to sell, we'll give you some liquidity. Here's the valuation we're doing it at. So that's one common place. You can also put obligations to sell in certain agreements. So if you have founders and for whatever reason you want the ability to take out that person's shares, you can enter into an agreement. The corporation can enter into an agreement with that individual to the right to repurchase their shares. It may be subject to the shareholders agreement. You can get around that with various approvals or stuff like that. But you can definitely structure it that way if you want to. There's nothing precluding you.
But if your liabilities exceeded your
well, if you're insolvent, you may not be able to make payment on redemption of shares. It's all may have to satisfy solvency tests. That comes into play more. If the corporation is insolvent generally, I don't know what to be doing. Purchasing equity from a.
Okay, but it's not it shouldn't stop a corporation if they have they have the cash.
If you have sufficient cash and you're not going to be insolvent post-purchase, a repurchase of shares for cancellation, it's a contract amongst parties as to whether or not you want to do that.
In worst case, just get the consent of all the shareholders.
Yeah.
If everyone agrees, there's no one can sue it.
Yeah.
Right, so we're going to have a Q&A session after this,
Oh, okay.
and also one-on-one meetings, so you can reserve all your questions until then. So these guys will be available for all of those questions. So let's just
Sure. Okay. Look at that.
Right, thank you. Okay, I'm not going to waste time with introductions. I'm just going to get straight into it. Okay, that's not my slide.
They should still be saved on the desktop as well.
Okay, let's see. Okay, so okay, all right, that worked. Anyways, so 33%, what does this number represent? It's, oh, my God. I'm having one of those days. Anyways, 33% was supposed to be the number here. So this percentage represents the percentage of startups that have filed for patents, and they did so before they even got it, before they received any funding at all. So this is an interesting stats because you usually get, startups coming to us and saying, hey, should we wait around and get patents, or should we go straight ahead and file? Now, does anyone remember what happened on January 9th, 2007? I'll give you a hint. It has something to do with yesterday's announcement. It was trending.
Election?
No? There you go. That's it. Yeah. So in 2009, Steve Jobs introduced the iPhone. And in one of these slides, he was talking about all these four phones. You had the Nokia, the Moto, and he said there was something wrong with all of these phones. They all had keyboards. And they were using up a lot of real estate that no one needed. You had to have this keyboard, and even if you needed it or not. And he said, we have revolutionized the user interfaces. You're going to see something that you've never seen before. And sure enough, he introduced the iPhone. He said, you could pinch and zoom, you could touch and, copy and paste just using your fingers. You didn't need a stylus, you didn't need anything. You just needed your fingers. And then he said, we invented this thing and we patented the hell out of this thing. But most people didn't realize this. They didn't actually invent, this multi-touch user interface. This was done by a young company called Fingerworks, which they had acquired about 9 months or a year before that. So Apple, has this habit of, it's a business model that they have. They'll acquire a bunch of companies, introduce their technology into their phones, and, you have these wonderful machines that we all love. So apart from Fingerworks, there's PrimeSense, there's Siri, Shazam, RealFace, the guys behind Real ID, Acona, Lighthouse, security company, and PrimeSense is, 3D graphics company. So you're probably wondering, sitting here, should I patent or not? This is one of those questions that you're going to have to deal with. You may think, you have an invention and you're wondering, should I go ahead with the patent? You're going to hear a lot of stories about, why you should and why you shouldn't. So, I don't envy your position right now because, it's a difficult decision to make. But to help you with that decision, I'll tell you two stories about two Canadian startups. One of them is Border Network Technologies. So in about 1997, they came up with this piece of software, and they were a firewall vendor, and they came up with this piece of software. And this software was to make it seem that 100 computers within an organization would appear as one, from the outside world. So this became known as network address translation. And a few years later, it was introduced in almost every router, Cisco, and now, on your phone when you do a hotspot, you're using this technology. But these guys didn't bother to patent it. And the CEO was being interviewed a few years ago, and he had many regrets. This was one of his biggest regrets, that they didn't have the wherewithal to file for patents. They thought it was something that wasn't going to be an industry game changer, so they didn't bother with patents at all. And they didn't have any money, and they didn't have the time, the resources, and all that kind of stuff. So he's not alone. I mean, if you ask most CEOs, why they don't bother to patent, these are some of the reasons that they give you. It's too expensive. It's $30,000, the life of a patent. From application, maintenance fees, and translation costs, and all that kind of stuff, it costs a lot of money. So most people don't do it because it's too expensive. And the other reason is that, to enforce a patent, if someone actually infringes your patent, you actually have to, defend yourself. So you're going to pay lawyers. And, this costs a lot of money. And most people, say, hey, we don't even have the money. Why even bother starting the process? And the other reason is that, sometimes the invention is not even patentable because someone else did it already. Someone did something very similar to it, or, it's very close to it. And so it doesn't make sense to get any valid patent that you can actually enforce. And lastly, people say, technology is changing so rapidly. Why even bother? Because, if I have something out today, within a year or whatever, it's going to be outdated. So why even bother? But what they forget is that, even if you do patent that, basic fundamental technology, that is something that other people can build on, and, they'll be able to, license that technology to those people, to those companies. Now, the other company was I4I, Infrastructure for Information. In 2010, they won a patent infringement suit against Microsoft. This is a 15-man, company, and they managed to, go up against these guys and actually won. And what these guys had was a piece of software that allowed editing of XML documents. And Microsoft took that piece of code, put it in their Microsoft Word, and, started selling it. And these guys caught wind of it, and they challenged them in court, and they won. They succeeded. And it's only because that they have a patent. They had a patent. Had they not had a patent, these guys would just taken that code, put it in Microsoft, sold billions of copies around the world, and gotten away with it. So these are some of the reasons that most CEOs, if you talk to them, give you for going ahead with filing for patents and protecting their IP. One of them is, investors love to see that you have something, valuable that you can protect. They love to see that. It's something that they can get their hands on. It's an asset. They can monetize it. They can sell it. If things go south, they can make money off that asset. And the other thing is, it actually defers people from, infringing your product. They won't copy you because, you have a patent, or even just patent pending. That's enough to scare people away. And also, people are not going to sue you because they're afraid, you might use your own patents against them. And in certain situations, when you're negotiating partnerships, if you have patents, that's something you can use as leverage. So that can be very helpful. And lastly, it also improves your chances of getting acquired or, an exit IPO. If you recall, when Facebook went IPO and Twitter went IPO, they were sued immediately by IBM. Because they also held some patents that were related to some of the technology for advertising, that kind of stuff. And in Facebook's case, Zuck actually went out and bought a whole bunch of patents from Yahoo and Microsoft in order to defend himself. And those guys just, walked away, basically. So you're probably wondering, do I have any IP, sitting here? So I'm going to use Jack here. I don't know if you guys attended last week's session. He was talking about his company, Orbiseed, and he went through the whole process of how they can take in 2D diagrams and convert them into 3D models, architectural diagrams and that kind of stuff. And they have a wonderful system. They've got a workflow. It's an AI engine behind it all, and there is patentable stuff there, right? But beyond patents, I know some of you guys don't have any inventions. There are other forms of IP that you should be aware of. So in Jack's case, once again, in Orbiseed's case, if you look at their name, Orbiseed, That's a pretty unique name. The logo, that's pretty unique. You can protect that. That's a brand. So you can use, trademarks to protect that. And also copyright, the code. That is something they can protect. Any manuals or anything that they've created, any graphics, that's something they can protect with copyright. And also trade secrets. They may have, certain agreements with other companies, partnership agreements, or contracts, or the revenue models. That stuff, that's trade secret. No one is going to find out about that because, if I'm a competitor and find out, I may have an edge over them. So, they want to keep that stuff as a trade secret. And the key to that is, to have, certain documents in place like NDAs and CDAs, confidentiality agreements in place so that, the secret actually remains secret. Once it's out, and, you really can't, have that trade secret anymore. And there's also industrial designs, but in this case, they wouldn't have, industrial designs, but that's something else they might have. Yep.
So I think patents are great. I've had some experience with one of my first startups with it, but now that I'm in the software industry, it's so tough to kind of go around and find out exactly what part of that can be patented because the software is an application. So I think it's such a different process and it's quite confusing.
Yeah, for software, it's a little bit different. It's a little bit different, and I'm sure you've heard in the U.S., there are certain laws that were passed, certain cases that are making it harder to get software patents, but it's still possible. It's just, how you structure the document, your patent claims, what are you going to put in those patent claims? There's certain language you should avoid using in your patent claims, and, if you do that and follow, the jurisprudence, you should be able to get your patent.
What is the typical process of a software, like an application to get patent on maybe the design or the UX or something regarding that?
Yeah, so typically a patent application to get examined and granted is about 2 to 3 years. So it doesn't matter if it's software patent, mechanical, or electrical. It doesn't really matter.
That process early is
Oh yeah, for sure. I'll get to that. Yeah. Okay. So once you've identified, what kind of IP you might have, whether it's trademarks, patents, copyright, industrial design, or trade secrets. By doing that IP audit, you can come up with some kind of strategy. What's your IP strategy? You have business strategy, so you must have an IP strategy. And so you have to align that IP strategy with your business goals. And you should also be thinking about, how you can actually make money off this IP. You spend so much time and effort, coming up with this IP, R&D, and it only makes sense that you should be able to get something out of it. And one of the things that you should be really looking at, when it comes to your strategy is, where do you file and, what are you filing? And these are some of the things that you should be thinking about before you make that decision. One of them is, identifying what your markets are. Where are you going to be actually, selling your product or service or whatever it is? Is it going to be strictly North America, or is it going to be Europe, or are you looking to, Asia and that kind of stuff? So you want to know, where you're going to be, market-wise. And you also want to know where your competitors are. If they're filing, in certain countries, they'll shut you out of that market, so you want to file there too. And when it comes to budget, patents are jurisdictional, which means that you can only get protection in one country. So if you were to file in Canada only, you only have protection here. You can't use that patent in Europe or, in the US. So you really have to decide, which countries you want to go to. And when it comes to certain countries like, Japan, Asia, Japan, China, Korea, and parts of Europe, you actually have to translate that patent document into the local language. So you're going to incur additional costs. And, for a typical document, you're looking around, $6,000 to $8,000 in just translation costs, unless you can, translate it yourself, which is not possible sometimes because of the technical language involved. And you also have to think of maintenance fees. So annually, you have to pay maintenance fees to the patent office. So these are government fees that you have to pay. So in Canada, it's around $200 a year, for the length of the patent, which is 20 years. And in the US, you're looking at about $1,000 every 4 years. And as a means to budget your, you can also employ other ways to defer costs, to defer costs with, provisional applications or PCT applications. which allow you to file one application and then you wait 30 months before, going into the specific countries. So instead of filing, let's say, 30 applications in one day and incurring all that huge cost, you just file the one application and, you keep doing your R&D and keep developing, and within 30 months, decide, which countries you really want to go into based on the market and based on, what's going on with the development. And the last thing you should think about is enforceability. When it comes to enforceability, what I mean by that is if someone were to infringe your patent, can you really go after them and get something, substantial in as far as damages? We have some very, good IP legal systems in, the U.S., Canada, and Europe, but in some countries it's just not there. So it doesn't make sense, to go to, certain countries because, you may end up with damages in the amount of, I don't know, less than $50,000 or $100,000. That may not be worthwhile. So that's one thing to think about. So cost is one of the questions I get all the time, and it's always really difficult, to give you a definite figure. But this is just rough estimates of the kind of cost you should be expecting, when you undertake, patents or trademarks. So with patents, typically, you start off with a provisional application, and this is just to get your foot in the door. This is just to say, hey, I've invented this, on this date, and this is what this thing looks like. And you describe it, maybe it's a 5-pager with a few schematics, drawings, and that kind of stuff. And you file it in the patent office, and then you wait 12 months, and then you do the full application. And that's the one that's going to be comprehensive. It has all the schematics, more of a description, a bunch of patent claims, 20 or more claims. And then it gets examined. And that examination process is a little bit long, so you're looking at 2 to 3 years before you actually get your patent. And typically what happens during this examination process is that an examiner is going to look at this patent application and do a search, a patent search, to see, if there's anything similar to your product or, what your invention. And they'll get back to us and say, hey, we found this, reference, it's very similar to yours. And then we have to argue that it's not if it isn't. And given the reasons and why, we think that our invention is better, or it's got more advantages, or the patentee in that prior art never consider certain aspects of our invention.
Is there a discovery phase when we are doing the filing with the law firm that will pick up similarities with other patents that are out there?
Yeah, so typically, we do a patent search before we even embark on applying for a patent application. And this is good because, it tells you, what the landscape is, who your competitors are, and the kind of other inventions that are out there. So that will allow you to actually, tweak your own invention, design around, certain features, and make sure that, you can actually get, your patent. Because ideally what you want to do is do your own search, because, examiners going to do the same search. So you might as well find out first, and then, tweak your own application before, getting that document, saying, you can get your patent, 2 years later. So if you do it prior, it's always better. And then I think I mentioned maintenance fees, which are due annually in most countries. And then with trademarks, it's a little bit more straightforward and less expensive. The whole process from filing to registration typically takes about 18 months. And, the costs are much lower.
Is the timing there just workload on their end, or is there a reason there's 2 to 3 years for the patent?
It's workload. It's workload, yeah. In Canada alone, they received about 36,000 patent applications last year, which is nothing compared to the U.S. You're looking at, hundreds of thousands. Sure. Yeah, so every Tuesday and Thursday, the USPTO publishes patent applications and patents. So if you ever are so inclined, go there and see, how many patent applications are published daily. Yeah. Yep.
What happens if during the review process, either another patent is filed or another patent is approved that was filed prior to the submission of this one? Does the patent search process find those that are pending, that have not?
Yeah. Okay, so this is when it gets tricky. So if you file the application today, it's not going to get published right away. Right? It's great. Yeah, it won't show up in the search. So it's confidential for 18 months. So you won't know about it. So it's likely that, you could file today, and think, hey, there's no prior art. And then 9 months later, this thing pops up. And yes, in the US especially, that'll be a problem. Because they don't really care whether it's public or not. They care about, when was it filed.
In Canada, is it different?
In Canada, it's different, yeah. So it's a slight difference. Prior art here is something that's in the public domain. Something I can find.
So would they end up approving both then?
Or it's two different countries, so there are two different laws, so yeah. So you could get a patent here and not get it in the US. Yeah, so I talked a little bit about patent searches, and these are the reasons that you might want to undertake a patent search. And this is something you can even do yourself. If you're able to put in the right search terms. You could go on Google Patents, or you can go on the SIPA website or the USPTO website and see what pops up when you put in various keywords. And I actually encourage clients to do that, because when they come to me, they're a little bit more informed as to what the landscape is. It's not just hey, I got the next mousetrap, and there's no other thing out there. Once you see something, then you appreciate that maybe yours needs a little bit more work, or there's no need for you to carry on at all. And for trademarks, it's the same thing. You want to do just a search to see if the name of your company or your products is out there, or if your logo that you're proposing is similar to others, because if it is out there, you're not going to get it, because the trademark office is simply going to say they're too close, they're likely to lead to confusion to the consumer. So you don't want to waste time on that. I mentioned at the beginning that one of the questions I get all the time is when do I file my my patent application? I got this great invention. Should I wait until I have an MVP, a prototype, working model, something tangible I can show to investors and all kind of stuff? And the answer is no. You don't have to wait until you have any of that. Once you understand how this thing works, you can put it together. And any competent engineer can look at this document and put it together. That's enough for a patent application. If you can describe it with, the adequate drawings and the claims, that's enough. So this is an example for Thalmic Labs. They had this armband. I don't know if you guys are familiar with it. You could control, gaming control. You could control PowerPoint presentations, and you can also use it for prosthetic limbs. If you had a prosthetic limb, you could control it, just using your gestures from your arm. So as you can see from this timeline, they came up with an idea in 2012. Filed a whole bunch of provisional applications before they even had an MVP of any sort, and kept on filing provisionals. And by the time they actually had the first disclosure of what they were doing, telling the whole world what they're doing, they already had a bunch of applications, and followed up with PCT applications, non-provisionals, and industrial design applications. So the industrial design application was last, because this is the actual embodiment of this of this product. This is exactly what it looks like. So this is what they were selling on the market. So that's what they really wanted to stop people from copying. So that's why they waited all the time until they actually had the final form of the product. And as you may know, these guys in July, they actually pivoted. They've gotten away from this. They discontinued this product, but they had a whole bunch of IP that they actually sold to Control Labs. So all was not lost. They've moved in a different direction, but the IP was still solid, and another company in the US was able to acquire that IP. So these are some of the common mistakes that we see on a day-to-day basis, that most people don't do any patent searches. They'll just think they can just apply for the application and it's going to get granted. That's not how it works. Like I explained before, you've got to do your patent searches. The examiner is going to do the same thing. So you really should do your patent searches and see what's out there. And the other thing is premature disclosure. And what I mean by that is the patent laws, they dictate that once you disclose your patent application, you start the clock running for the time for you to actually file an application. So in Canada, the US, once you disclose your application, let's say today, you have 12 months for you to file that application in the US Patent Office or the Canadian Patent Office. But in other countries, once you disclose let's say Europe, in Europe, once you disclose, you cannot get a valid patent after that. So it has to be confidential until you file the application, until you actually file the application. So most people are not aware of that, so they're happy, to go to TechTO and talk about, oh, we've done this thing and blah, 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 and then, then they turn around and say, yeah, but our biggest market is going to be Europe. So you got to be very, very, careful about, public disclosure, of your invention before you have filed your application. So, and the other thing is, forgetting those key dates. When did you actually disclose? Was it yesterday? Was it 2 months ago? And some people are not so sure. They don't have records of exactly when they disclosed. And those dates are critical. If you miss it by 1 day, that's it. You're out of luck. Yeah.
So, patent disclosure is when you tell somebody about what it is that you're doing.
Exactly. Exactly.
Not about your intention to submit a patent.
No. Yeah. So this is, you describing, oh, I got this amazing microphone, and it's got this, all these components, and this is how they fit together. And, here's a diagram. Look at it. Isn't it fantastic? Whether it's on your website or, you have a white paper or, you get up, on stage and talk about it at any one of those pitch competitions. That's public disclosure. So you got to be careful about that. And I think Graham touched on this, IP ownership. That's like that's the biggest thing that we see that, most companies do badly, when it comes to IP ownership is, they don't realize that, when someone invents something, they own it unless, they assign it to the company. So unless if there's not a document that says, I've transferred my IP rights, to this company, then, that inventor is the owner. And if they quit tomorrow, they walk out with that IP. Go ahead.
Anecdotally, I've worked on 2 transactions in the last year, and this has turned out to be a huge issue. One with patents that weren't properly assigned or registered in the name of the company that they're buying, so they weren't buying effectively nothing.
Mm-hmm.
And the other one was with investors, and their whole IP portfolio had people who were previously involved in the company named as the inventors and everything like that.
Yeah.
It was just a mess. And when you're talking about getting investors securing $10 million or selling a business for $5 or $6 million, these become very, very concerning issues to you at that point in time. They should be concerning issues right from the get-go. So it's important to do the IP strategy, get your
Absolutely.
IP business plan put together, and make sure you know exactly where you are, what that on your registration and filings.
Absolutely. Yeah. Go ahead.
So with the proper employment contracts for employees, can you cover that off?
Can, but often when you're doing IP patent filings, you have to name the inventor and stuff like that, and that may be someone who is no longer with the company. You need to get the assignment forms filed at that time or filed shortly thereafter.
Yeah, so we typically have separate agreements, so an IP agreement. It's got nothing to do with employment. It's just, any IP that, you come up with, whether it's copyright, trademark, industrial design, or patent inventions, they belong to the company. So that's separate. And it's a 2-page document, easy to understand. So you should be able to, have your employees, sign it. Pretty straightforward. And the last thing that we see all the time is, people trying to do this, filing themselves, filing these applications themselves. Yes, it's not difficult, to, describe your invention and, and file it, But, there's a lot of, jurisprudence, a lot of laws, lots of cases that are, will be able to guide you, to do it the right way. And trust me, there's a lot of this stuff going around, and most of you guys are not up to speed on all the laws and all the changes in the laws that are happening. So it only makes sense, to have, people like, Graham and Aaron and myself, help you with that kind of stuff. Because the last thing you want to do is, file this thing and, hey, patent pending, I got this thing. And then, you have this false sense of security. And, when you're going through a due diligence phase or something like that, people are asking, who drafted this thing? What does this mean? You don't want to end up in that situation when, a lot is riding on it. So best practices is, keep quiet about your inventions, until, you're ready to really disclose. And, you've searched and filed your applications, and make sure that, you own your IP. Thank you. Robert?
still gonna need to use that.
All right. All right, we'll just wait for it to get set up. I guess the recording's working. Can everybody hear me just talking normally? All right, great. Wait for them to go to start. Good to go. All right, so I'm one of the founders who's going to be talking to you guys tonight. I am not a lawyer, so I'm kind of going to give you a quick overview of, who I am, what our company does, where we're at, just to give it some context, and then kind of go down my experience of going through the legal process and the things that I think we did very well and other things that we did very poorly that hopefully you can avoid and hopefully put some of what you've heard from Eridan Bernie and Eridan Bearless tonight into context. So we're Forsen. We make a digital sense of touch for high reliability robotics. Specifically, we work in surgical robotics, industrial robotics and automation, and aerospace and defense. So those are our three industries. In surgical robotics, we are replacing a surgeon's sense of touch with robotic systems now taking the place of direct manipulation of scalpels and instruments. We are trying to give the robots the ability to sense with the same precision that a surgeon did. In industrial robotics and automation, obviously they are trying to do increasingly difficult and complex assembly tasks, so we help them there. And with aerospace and defense, one of the big things has always been control of the systems. How do you easily and quickly control an aircraft, talk to somebody, and right now they still, they take a mic and they hit the button and they walkie-talkie to each other. And they still use a very, very complex series of buttons. And with just about everywhere else in the world, we've gone away from that. So we are adding new sensing capabilities into that market. And we exist because of new market trends. Specifically, they're looking to add more sensing technology into more and more robust, harsher applications. And the sensing technology isn't really in a space to do that. It's generally been designed either for traditional industrial, where it's very large, heavy, and bulky, or it's been designed for consumer electronics, where a stiff breeze will destroy it because the product's only designed to last 2 years, so you buy a new one. And people are starting to work closer and closer with machines. There's robots working alongside surgeons, working alongside factory workers, working alongside aerospace. And lastly, everybody wants all of that capability and everything built into the exact same size it was before, when it was a dumb machine. So trying to fit all of that technology into the same space that it was before, and the old industrial sensors really aren't designed to do that. They're designed to be quite bulky. So we invented a technology to do this. We invented a very thin film that you can laminate into just about any industrial application to give it a digital sense of touch. It can work in any environment. It is incredibly thin, incredibly light, and allows incredibly dense sensing. Think of it like a central nervous system for machines. We are incredibly capable control systems. I can move this around far more dexterously than any robot can, and we do that with a very complex central nervous system. So that's what we created. And we have a pretty experienced team. So myself and our lead engineer are both PhDs in engineering. We have an operating officer now who's part of the founding management, Celestica, who some of you may know. They were kind of a Toronto darling for quite a while. They made everything for Cisco. And we also have a BD lead. Because what you'll find is as your company scales, you can't do everything. So nowadays, as the CEO of the company, I don't get to touch the nitty-gritty of technical or do most of the customer discovery. My job is to set vision for the company, do some of the high-level technical layout, raise money, hire people, and close deals with clients. You will see your life evolve in a very similar way, hopefully, as things move along. And we have some great advisors, both of whom built their own companies. And right now, we are in this state of actually rolling this technology out into the field. We have 3 contracts that we are actually delivering. We have another 6 contracts. That's our goals for this coming quarter. And we have over 20 NDAs. Actually, that's probably over 30 now with major clients to integrate our technology. So those are, you should probably get some help with those NDAs. It's nice to have a boilerplate one that you can just send them to keep things going smoothly. Yeah, so we're making amazing demos and building out custom prototypes for customers. So that's where we are. And I learned a lot about what you should and shouldn't do from a legal perspective when setting up your company. So the first thing that we actually did well, I always like to, it's always nice when you actually didn't screw something up when you started out, is we actually incorporated the company and we assigned all the IP to it. I know you heard that a lot. That's important. That's a key thing you should do. Because my co-founder applied to go to med school behind my back, got in, and one day told me, hey, I got into med school. I'm going to leave. And we'd invented the technology together, at least on paper. Realistically, I knew how everything worked, and he ran a bunch of the tests. But he was leaving now. Out of the blue, you never know when this might happen, and thankfully, he had completely assigned his IP to the company. And in fact, we even had an agreement in place, colloquially known as a shotgun agreement, where if somebody wanted to leave the company, then there was some mechanism to get them out. Both of those are things you should look into. If you're just a few founders, I know that we didn't talk about shotgun agreements, but if there's 2 founders, the other person's going to own half the company. If they decide to leave, you need some mechanism of resolving it, because my co-founder actually wanted to just go to med school and kind of just keep his ownership in the company, and that would have complicated fundraising a lot. So those were 2 things we did incredibly well. So once you file your IP, which you should, and you have a company, make sure it's assigned to the company. We did that well, and it saved us so much headache. Next thing is everybody who comes in the door to work for you, even co-op students, get them to sign NDAs. Make sure they understand what an NDA is. Because a lot of students coming in, co-op students, have no, I guess, appreciation for how important this is or how important it doesn't get out. So sit down, explain it to them, and make sure everybody signs an IP agreement, even if they may not be directly involved in what's going on or they're not named on the patent. They can always come back and say, it's, I was involved. It's like maybe they just took minutes at the meeting, but you'd have to prove it in court still. And that could be a really big pain later on, so it's just nice to have that blanket, and that's pretty standard. The other thing that's nice is take a bit of time, learn what's patentable and what's not patentable, so that you're not spending a bunch of time or wasting a bunch of your lawyer's time trying to figure out what your invention is or if there's anything there at all. And before you go and bug them, at least do a Google patent search. So Google Patents is great. If you came up with it, chances are somebody else thought of it. So go take a good look, Google search first, Google Patents next. If you're clean after all that work and really try and make sure that you're clean, then come to your lawyer. The very next thing after that is don't rely on Google Patents. Don't stop there. This is just like a sanity check to make sure that you're using your lawyer's time well. Because I've seen a lot of people who, it's like you have no IP here, or did you do a simple Google search on this to make sure that it doesn't exist? And then, even a Google patent search, learning to do that well is helpful. And you'll get better at it as you go, and some of the universities actually run courses on at least how to do a basic search. And finally, this is something that we didn't do well along the way. Thankfully, Tony was very straightforward with us from the beginning, gave us good range, told us what it was going to cost, told us when it was going to cost it. Not all lawyers are that good. So we've had circumstances where we were told one number at the start, and then at the end they came back to us with something that was an order of magnitude different than what they had said. And at that point, we didn't really have any recourse. We hadn't monitored them, and they just said, here's your bill. And it was one line and then an exorbitant sum of money. And they thought that was okay. And some of the firms will do that, and this was a very large and would probably be considered a reputable firm. So do make sure, Aird and McBurney, every time I've worked with them up front, has told me they've said numbers, they've kept to their numbers. This is a good firm to work with. Not everybody will do that for you, or at least not everybody will do that for you by default. So do be careful, and just for your own information, know how much things are going to cost up front. Legal is not cheap, but it's incredibly important. So make sure you know what your spend is going to be, so you're budgeting for it, and then, make sure they're actually sticking to that. So get updates as they're going along, so that if something does change along the way, you have some ability to correct it before you get a massive, massive bill that you can't pay, or at least it would come out of massive budgets. And remember the part where I said I'm not a lawyer? And I know you like or have said you're quite good at convertible debt. I went through convertible debt. I raised all of the money to date on a convertible note. They cost money. They're not cheap. And I've known a lot of companies who raised on safes, and it cost them basically diddly squat. And
well, if you can raise on safes, raise on safes. I'm not disagreeing with that. If you can do it, do it.
Yes, I spent $30,000 doing convertible notes between my counsel and their counsel. A couple of my friends who raised on safes spent $0 and no time negotiating anything. They just went, they signed a safe, they got the check, and they were out of there. That's a great process. I like that process, and then you can save all the complicated stuff for when you raise an equity round. The convertible note gets complicated.
Just high level, what's the difference?
So I'll try and answer this as best I can, and then you can chime in when I'm wrong. A convertible note is a debt obligation. So when you give me money, it is now debt in my company, which either comes due at some point, I need to pay it back to you, or if I raise enough money or get to a big enough exit, then it automatically converts to equity. Do be careful about that though, because a safe is a standard thing that Y Combinator came up with. So it's a very standard document. Convertible notes may not be so standard. So one of the gotchas that I actually spotted along the way is our investors wanted the ability to convert their equity at any point. There wasn't an automatic conversion for them. So they can change things around on you, and it's not a standard document that everybody will know. That's why it took both sides so long to read the documents and negotiate. A safe, on the other hand, there's no debt obligation. If things go poorly, money's gone. So you don't have to pay it back at a future date, and it's exactly what it sounds. You promise to give them equity when you raise more than a round, but it can still have a lot of the features of convertible note. It can have discounts, it can have caps, all those things. I would highly recommend it if your investors are amenable to it. It's a new thing in Canada, so some may not be. We raised from angel groups, and they still liked convertible notes.
Convertible notes are also usually going to give you a coupon or some interest on your money in that interim period. So the investor's getting money up front with some upside to get equity. They say if you're putting money in and saying, no idea what this is worth, I see some value in you guys, here's some money, we'll let the next big investor tell us how much it's worth, and we'll get a discount. So they're deferring it, and it's designed to be it's a simple agreement for future equity. Simple is the key. If you can raise money on it, great. It really comes down to what is the investor's risk appetite and how comfortable are they with new things. But as a company, what you're really saying is, here, I'm going to get some money for free, and I'm promising you an investment later. That's a pretty good deal as a company, as long as your discount isn't too big down the road. But
Yeah.
So it's literally simple agreement for future agreement.
exactly.
Yeah.
So,
Y Combinator came up with it. The other thing that's nice, if your investors aren't sophisticated and they have a thing that they're, set on, a good way to sell it is, I'll have $30,000 more to work on this company. A lot of them are going to be giving out check sizes that are probably on that order of magnitude, and you can basically tell them, I will not be spending your investment going directly, well, to the lawyers, but sorry about that, guys. But yeah, that's a great way to sell it.
At what point would you say a price round, you will want to do a price round to put the valuation there? Right now, we're raising a lot on stage with angels.
Yep.
But one of the things, right, that like we're putting caps on there just to make sure, that they get the idea valuation. But at some point, I'm assuming you probably want to put the price on the round. At what point would you say you recommend it to do it?
Put a price on the round. So you want to kind of defer that, at least in my experience, as much as you can, just because doing a proper priced like Series A round has quite a bit of legal expense and quite a bit of closing. Right. Usually you do a priced round because you have been forced to. So if a venture capital firm comes in, it will almost always be priced. There are micro VCs and family funds who might do something different, but they're going to come in for a priced round. Or at some point your investor is going to push you to do a priced round so that they actually get equity. So that's where it's going to come in, is you're kind of going to be forced into it, but it is expensive. I have seen companies spend anywhere from $50,000 to $100,000 closing Series A, and let me know if that's a normal amount, but that is what they spend, and these were US VCs.
Right. So if let's say you're giving a standard term on the price round, like what kind of ranges would you be expecting?
In terms of evaluation?
In terms of sort of say right, because it's really a cost benefit approach. Let's say if you want to do a price like the standard term with a price round, the terms are fairly standard friendly. What kind of sort of pricing do you have a rough idea?
In terms of how much it takes.
Legal fees?
Yeah, legal fees.
Yeah, these guys would be better. I've seen people do it for $40,000, $50,000, and that's my last point. Is you're already reinventing the wheel with your business. Don't try and do it at the same time with the legal system. Like, use boilerplates. They exist for a reason. They've worked well. I've seen people try and come up with weird agreements. If you do weird stuff in your seed or your Series A, it's going to make weirder stuff happen, and it's just going to cascade.
I think VC fund will have standard form of agreements that they've used and come with in the past, so will our council. And there's really probably about 5 points to be negotiated. And once you get those points settled, you should just let them paper it and just be done with it. And like I said, don't reinvent the wheel. You're not gaining any value from it.
Yeah, don't make more points. Those 5 points are going to take long enough for you to negotiate. You have limited runway. Your VC does not. So you will lose if it comes down to negotiation, because you will die.
So which 5 points?
Well, if it comes down to a Series A, valuation is a big one. Board seats is going to be the second. Any sort of intrinsic rights they may want. And then it comes down to how the preferred shares are set up. Do they have ratchets? Do they have waterfall? Things of that variety. Yeah, and then basically veto rights and things of that variety. They could, and the last thing that they can do, which is kind of weird, so point number 6, if you're dealing with a corporate VC, they may want right of first refusal on acquisitions or IP or distribution rights. That's very common. If you get an Asian firm to come in, they're going to want distribution rights probably in the Asian markets. I've seen 4 companies do that recently, where they've not led the round but come in and they just wanted the distribution rights as a special right. Anyway, that's it for me. I probably took up way more time than I was supposed to.
So just follow on point, strategics, like investors they'll come on board and they'll want first mover access to your technology. They may not block you out, but they'll get you involved. They'll get an all exclusive in perpetuity licensing agreement with you, like Cisco, IBM could even, as part of their investment money they put in, and you're going to grant them that right to basically use your technology. They don't own it, they can't do anything basically with other integrated systems, but that's part of what you pay for when you get those strategics on board. We act for a number of them.
Yeah, and you can scope it. Like you can be like, you can use my technology just for consumer mobile devices.
Right.
Or you can scope it in terms of a market. Like you can use it for consumer mobile devices in the US. That way you can kind of piece and pair it and you're not potentially giving up other markets. So yeah, because if Microsoft is the only customer that you can have, then Microsoft can do whatever it wants. So you want to have some other market that you can go and make money from so that they're not your only customer.
We helped lead an investment round on Series A, and the company, the strategic investors leading the round, they had a bunch of other VCs come in. That company did a spin-off and sold for over $200 million US. And it was a strategic lead the whole way, and they just kept on to their exclusivity on one piece, and we're happy to see the rest of the company go. So.
Yep. Awesome. Oh.
Sorry, I thought I just wanted to add a couple. So I raised close to $2 million on a safe, on a few safes, converted it into equity round. There are reasons why you don't want to carry your safes forever, right? At some point, your equity investors start to look at them as a bit of a liability if they're accruing for a really long time. So as an example, let's say
Convertible debts, you have interest.
Let's say you raise on a $2 million cap, okay, and you've got whatever you've got managed to get $200,000 into it. You essentially sold, assuming you exceed at your round $2 million, you've essentially sold 10% of your company. So if you go on forever, you have the great problem of having done amazingly, and now you're looking at a valuation of 10 million, 20 million, 30 million. Your new investors are coming in going like, well, these guys are going to take 10% of this company for $200,000, and that's not as cool of an idea to them as you might hope.
Well, yeah, just be upfront with them that as far as the safe's concerned, once you're at that point, they effectively already own the shares. So that they won't be on the cap table, but it's nice just to put a big note at the end of the cap table, or like even gray it out, and just like put a clear note like, these people basically have shares. We have raised so much money and we are doing so well that they will convert, and just treat them like normal shareholders. So when we do our convertible note, we're very upfront like, look, these people have this much, and here's the cap and here's the interest. So here's how much they effectively have when you invest. So treat them like existing shareholders. It makes it simpler for people rather than them having to look through all your warrants and convertible notes and safes.
There's also a complexity that comes with having safes on, a whole different, a number of different rounds of these things, and the order in which that cascading kind of conversion happens, which, when we did the price round last year, it actually took a really long time for any two, highly trained lawyers to look at our series of conversions and go, I think your cap table looks like this.
Yeah.
Right. So it got complex.
Yeah.
Would you recommend having one round convertible note?
And that's because of dilution, by the way.
I don't think you
So
can
one person's going to come in and they're going to own like 10% of the company, and then if the other person comes in and they want to own 10% of the company, well, that other investor just got diluted. So were they in the same round? Did they convert at the same time? Do they convert at different times? And that affects whether they each get 10% by converting at the same time, or whether one gets 10% and the other one gets less than that because they got diluted.
Another thing sort of along those lines is valuing at pre-money or post-money. And this comes up all the time, and if you watch Dragon's Den, you're probably confused. But there is a big difference, as in, is this company worth $2 million after I put in the money, which is equity usually, or before that? Those are two very different valuations, because if you're adding in $2 million of equity, the value of that company just went up by $2 million. You're literally dumping cash in. There's a big difference. You might think you're getting a great valuation, only to discover, oh, it's on a post-money basis, for example, and it changes the game.
So would the investor tend to want to do that post, or for before.
I don't think there's a right way or a wrong way. It's just about
It
everyone
just
being
makes
on
sure you know
same page.
the nomenclature, because they can be like, we're we want to give you $1 million and we're valuing you at $2 million. Pre or post money is pretty important, because one of them, yeah.
I think marketing-wise, pre-money sounds better because it sounds like they're getting better deal, and then post-money, if they ask for a certain percentage, I think that's usually for post-money.
Okay, let's move on to the next one.
Yep. Thank you.
All right. So I'm just going to pop this up. I didn't know that we got a NASA engineer to do this.
It's fancy now.
Okay.
There you go. So just pop that in your back pocket.
I'll just keep this in here.
Yeah, and I'll clip this to your back pocket. Is that okay? Your belt.
Okay, so here's my belt.
There we go. Go ahead.
So do you need to check the audio? Okay. Okay, cool. Thank you. The clicker? And how much time I have?
15, 20.
Okay. Hello everyone. I hope you can hear me well. Cool. It's just, I think you can hear me well. Okay, cool. Cool. So it's a pleasure to be here tonight. This is not the first time I'm mentoring at Foundry Institute. Always great to meet brilliant emerging CEOs and of great startups. And what I'm going to share with you tonight is just few slides, mainly reflections of my own experience moving from the corporate world to a startup myself. Okay? So the first thing I would like to do is, we spoke about lawyers, and I think lots of lawyers spoke tonight. We also work with lawyers, and they needed to make sure that anything I share tonight is just a reflection of my own personal views. It does not link to the company. Okay, so very quickly, how fast did you ever drive? 335. Okay?
In Ontario? 200?
Wherever. Keep in mind, we've got lawyers in the room. Okay, 335. Well, 200.
240.
240.
100.
That's okay. If you are on a road that has a limit of 40 and you're driving 100, you're already too fast, right? Anyone else? The lawyers?
180.
180. Anyone else? Tony? 7-ish. Okay. So 335, right? This was kilometers an hour or kilometers? Okay. Okay, cool. So the next one is, what's the smallest car you have ever driven? Smallest car.
Fiat 500.
Fiat?
500.
Okay.
Golf.
Golf. Smallest car. What, do you know the CC? Do you know the CC?
500.
500 cc's.
Mini.
Mini? Okay. Mini Cooper? Yeah. What's the CC? Okay. Let's say 1600. Yeah. Okay. What's the CC? Okay. So I think let's take that example. You're driving the Fiat 500 cc and you're driving it at 335 kilometers. You are taking your smallest car ever and driving it at your fastest speed ever. Have you ever done that? If you have not, you're already doing it with your startup. Your startup is the smallest car ever, at the stage where you're at now. And what you're trying to do is to drive it at the fastest speed ever, because the faster you can go to your next milestone, you can upgrade your car. I need you to keep that in mind when you start your journey as a CEO. Yes, you might think of your car, your company, as a Rolls-Royce, but it is not a Rolls-Royce today. It's the Fiat 500cc. However, if you only drive it at the speed of a 500cc car, you will run out of petrol very soon. Keep that in mind, okay? Hi everyone, my name is Mo, or Mohammed Cheta. I used to work in corporate world. I used to be the global head of consumer marketing at Johnson & Johnson. Amazing job I had, honestly. And at one bold moment, or a crazy moment as my wife describes it, I decided to quit my job and become a full-time tech entrepreneur. I'm currently the CEO, the founder and CEO of IceTech. IceTech. So we are a human attention AI company. We believe that a moment of your attention is the most precious currency of tomorrow. What we do is we have developed a technology that we can measure how much attention you can pay to a digital environment, store that in a reserve of value as a token, trade that, and help you even get a higher return on that. I think Tony spoke a lot about patentability, being in stealth mode. We are in stealth mode, by the way, and we've been in stealth mode for a year and a half right now, and we are going out of stealth by end of the year. So you will find that if you visit our website, intentionally, we did not put many details on what we are doing because we got exactly the perfect advice from IP lawyers, which I think Tony was trying to give you similar advice today. And honestly, I think they made a significant advantage to us by doing that. We already have patent filing in process, provisional in the US. And by the way, we have 2 offices, one in 2 continents right now. This is all what I would like to talk to you about today. Actually, what I would like to talk to you about today is mainly reflections from my experience as a tech entrepreneur for the last 2 years. And before that, my 2 years of, I was doing mentorship as well for startups. Who is here is a CEO of a startup? So almost everyone. Okay. Who is here a first-time CEO? Okay. What exactly is your value to the company as a CEO? What exactly is your role? Vision. Okay.
Not to have any accidents driving 3
No accidents. Okay. No, lawyers will not be happy with that.
Protect the company.
No, yeah, of course, because the more you get into problems, the more you create more issues for the company. And as I said, lawyers will not be happy with having more issues.
Attracting capital.
Attracting?
Capital.
Capital. So funding. What else? How? Yeah.
Building a team.
Building a team. Yes. Anything else? How would you translate that into a measurable figure, a metric? Is it number of people, number of capital, number of litigations, success of the company? So let's say that success of the company. How do you measure the success of the company? Sales, investment, profitability. Is Uber profitable?
No.
Are they successful? the best VC-backed story in Silicon Valley in the last couple of years, right? So let's say that the real value of you to the company is actually valuation of the company. Because your vision, your funding, your team, your execution, all of that can be measured in one simple metric among many others. It's the valuation of the company. If you attract a great partner, your value of the company grows. If you don't hit any bumps, your value of the company grows. If you achieve more traction, your value of the company grows. If you attract the guy who was here, if you attract him back to the room, and he is a senior executive in the industry, the value of the company grows. So actually, you can simply or empirically say that your job as a CEO can be easily traced on how much valuation you are maximizing with your company before and after, right? And that's the very simple terms of, I think, a CEO job. What I really would like you to do is I need you to keep that in mind in anything and everything you do. Anything and everything you do is about how am I maximizing the value of my company. If I'm having a lawyer's conversation, how is this going to maximize the value of my company? If I'm sending an email to a customer, how is this going to maximize the value of my company? Because I know if I have to do 1,000 things and I can only do 10 of them, because I'm a human being at the end of the day, I will choose only the 10 things that will maximize that value. Okay? We agree on that? So let's talk about legal setup as a way of maximizing the value of your startup. And we're happy that we attracted you back to the room. So the first thing is that, what exactly is incorporation? Is it a formation of a legal entity that can enable you to do commercial transactions? It could be described as that, right? However, if you really look at it from a different perspective, that what I'm building is I'm doing a corporate design. And that corporate design is going to be a fit for purpose of what my company is going to deliver and how am I going to exit. In this case, you will think of incorporation as a way of executing that corporate design. Let's give an example. You are doing a deep tech company where when you would exit in 5, 7, 10 years from now, you know that your biggest value when you exit would be on your IP value, not on your distribution value, right? So in this case, if you really know that upfront, and if you really design that upfront, your corporate design, your incorporation strategy would be very different. Because you might consider doing an IP holding company where you keep all the IP in a parent company, separate that from the trading or commercial organization. So in case there is any risk or litigation from the trading organization, your IP is secure. If you really think of incorporation as a way to maximize the value of the company, if you think of it as a way to execute a corporate design that will give me a competitive advantage when I go and trade, when I go and exit, you really would start exploring questions that you never thought of. So rather than I go to my lawyer and tell him how much does it cost at a minimum to incorporate a company, and let me do that, because actually, how many times you can incorporate your company? How many times you can give birth to a baby? Okay? If you do, honestly, some people would tell you, you know what? Go and do online incorporation. You know what? It costs $100 or a couple of hundreds of bucks. Yeah, you can do that. But actually, I think the cost you're saving now is not really worth the cost of correcting a mistake. You might need to do this later on. And as I said, if you really think of it as I am executing a corporate design, it's better for you to think first, what is the best corporate design of my company? So that I can be having a competitive advantage. How many of us know that Google, for example, is invoicing you from Ireland? Do you know that? Why they are doing that? So there could be some tax advantage, right? How many of us know that, without names, some big names in the industry are having their IP in Luxembourg? Or they are having another entity that is receiving funding in a different location. Incorporation is not to give you an INC dot entity and that's it. I think if you really think of it in that way, you are oversimplifying a question of birth to your company that will impact how you can take care of it when it grows. So the first thing you do is that I believe you should do it right first time. The cost of correcting it is way much more painful, not only in terms of financially, in terms of headache, in terms of paperwork, than just doing it right first time. And for you to do it right first time, you really need to talk to the right people and ask the right questions. The second, sorry. The second thing is that have you ever tried to ask a password question? A question, just one question, that triggers out loads of data points that it's exactly as if you had the right password to the exact valuable data points that you were looking for. I think one core thing of a CEO is never to feel shy of asking questions to everyone and anyone you meet. The problem is that people have very short attention spans. They cannot really answer and give you all the details you need by just guessing what you exactly need. So one of the key things you really need to do is do your homework very well. Understand the basics before you engage with key conversations, particularly with lawyers, honestly. And you know what? Don't talk to one lawyer. Talk to more than one, because you will really learn a lot. If you, for example, working with one firm, talk to the patent guy, talk to the incorporation guy, talk to the employment guy. The decisions you will take will be much more well-rounded if you really understand the implication of one decision on different elements. However, you need to really learn how to ask a password question. Just one simple question that triggers a wealth of answers. And this can only happen if you keep in mind that your true north is the valuation number. The valuation number can really help you ask yourself, okay, if I do it this way, how is this going to be reflected in my valuation? Is there a better way? What's the cost of risk on that? And my last point is that you'll be working with lots of partners, lawyers, tax advisors, accountants, many, many people. Every one of them has a role to play in your journey. You remember, you're taking your Fiat, driving at 335, right? No lawyers, no policemen on the road. And your job is really go through all the bumps you can never expect and reach there where you would like to be as fast as you can, right? So you'll really be working with all of those guys. Every one of those in your journey has a role to play, right? What is the role of your lawyer? Yes? This is how I believe. Actually, my lawyers are my out of jail card. So if your lawyer is your out of jail card, you better pick the right card, right? And I think you are already on a great path. Honestly, the feedback and the presentations I have heard from Graham and from Tony are extremely helpful, extremely valuable. Honestly, the value is more than just the 20 minutes it took to present to you guys. Reflect on these and really look at how you can maximize the value of that, because they are really giving you amazing help. I wish you every success. If you have any questions, happy to answer them.
Thank you.
Thank you.
Thanks, Mark.
So no questions? Fantastic. Okay. Thank you, guys. Oh yeah, sure. Thank you.
Thank you very much.
Thank you.
All right, James, just a couple on you there.
Sure.
And just stick that in your back pocket.
Okay.
Okay.
Are we sitting for this?
I guess we are. I mean, do you want
Change it up?
What do you want to do?
Well, we're going to do like a fireside chat.
Yeah.
Okay.
We'll sit down. Unless
Sure.
you want to do something different.
No.
All right. Yeah, so really fortunate to have James with us today. James, who is CEO of InnoSpace. And, so I guess, the best thing for to get this started would be just to, tell us a little bit about InnoSpace.
Sure. So InnoSpace is at its core an indoor intelligence company. So we help companies that operate large portions or large swaths of commercial real estate understand the utilization of their spaces, understand how their space design impacts their productivity and their operations, and ultimately our customers use our platform to drive more productivity, more efficient operations out of their workforce, and better understand the efficiency with which they use the really expensive real estate that they pay for.
Okay. Yeah, so I saw you at Collision a few months ago, I guess May, and you're on stage and you had an amazing presentation, and I know you guys are going across the world, signing all these contracts and agreements and whatnot, and going into all these markets. Just walk us through what you guys have to go through to get to that stage. How do you get to that stage?
I mean, the truth is you get through that stage through a lot of hard work, but also a tremendous amount of luck, right? So everybody starts with an idea that they think and they truly believe is amazing. But an amazing idea and truly hard work requires, being in the right place at the right time. It requires the wherewithal to take phone calls or take meetings that you never ever thought would, that would lead anywhere. As an example, we have a partnership agreement with the 6th largest employer in the world. They're a multi-billion-dollar company. They are all over the place. And so this partnership agreement establishes us as the providers, their sole provider. It's an exclusive relationship. So it's this very lucrative opportunity that came to me when originally I took a phone call from somebody who was operating this small little startup that did something around art installations out of Miami. We had a conversation and that was it. And then a couple of weeks later, he called me back saying, hey, a friend of mine would like to speak to you. I think he has some opportunity for you. So I said, sure, I'll take that call too. That friend ended up being the CEO of Compass Group. Yeah, and so from that first phone call of a small startup with, that I didn't really see a whole lot of opportunity for, it led to a call with the CEO of Compass Group, which led to this partnership agreement, which led to, that partnership agreement actually was what allowed me to, was the sort of the catalyst that allowed us to close the round of funding that we did last year. So, from a call from an unknown guy that I didn't see a whole ton of value in, to a very lucrative partnership agreement and the ability to close a required round of funding. If I hadn't done the first one, and we never would have done any of the things that fell out of it.
Yeah, okay. So you've closed a few rounds, so I'm sure, you've gone through a lot of due diligence, with investors and the like, So what's that process like, from your perspective? Is it something you enjoy doing, or is it one of those things you just wish someone else would be doing it?
If you could hire somebody just to do it for you, it would be amazing. Except unfortunately, you don't have the money to do that. It's exhausting, it's brutal, it's painful, and the degree to which they will go through everything with a fine-tooth comb is exceptional. Which is why, all the things that everybody has been saying this evening around, planning for it, preparing for it, doing it right the first time. You don't really think about it at first. You have this amazing idea. You've got a co-founder. Maybe, you're excited about what you're doing, and you're just trying to move fast and get it done. You don't want to think about, IP assignment agreements. You don't want to think about shareholders agreements. If Innerspace, I started with a colleague, a former colleague at the time and a friend. And when you're going through these things and the lawyer's asking you about your shareholders agreement, well, what are you going to do in this situation? We're not going to be in that situation.
Yeah.
We'll agree. It'll be fine.
There'll
right?
never be a divorce.
Right. And there hasn't. We're still good friends, but we had to go through when we started the company, we were like, it's going to be all equal. We'll be co-CEOs, right? And then at some point down the line, you're like, that can't work anymore, right? Somebody's got to be, very few investors will invest in a co-CEO structured company, regardless of how hard you argue that it's fine. But the reality is somebody needs to be able to break the ties and make the decisions and be responsible for, ultimately responsible for things. And so when you have that conversation with your co-founder who's been there with you from the beginning, it's a really difficult one. And if you don't have things structured correctly in your shareholders agreement and your partnership agreement, it might be a deal-breaking conversation.
So as a young company, at what stage did you guys start thinking of, IP and all these agreements? Was it immediately, or was it after, investor told you, hey, you don't have this and that, and when did you start really getting?
So one of the first things we spent money on was the patents that are still slowly working their way through the patent process. Part of it was because where I had been previously with my, when I was an employee at my former employer, I was a product guy and I worked on a lot of patents and I understood the value of it to the company. But the other part of it was what we were building was very technical, and it was a technological advance that was going to enable all the things that we've done since. And so we knew that if the opportunity was what we thought it was, and that competitive advantage was due to the technology that we were building, then we better protect that technology in order to protect the competitive advantage.
Yeah. Okay. So in my my presentation, I talked about how legal and IP, not every CEO wants to spend money on that kind of stuff. It's the last thing you want to spend money on, because you'd rather be building a product, you'd rather be keeping the lights on. How do you make that decision to say, this is really critical? This is something we've got to do. We can't put this aside.
Right. It's tough, particularly in the early days if you don't have any money to spend. It's a really tough thing to decide, do I spend money on a patent process that may not see any fruit ever, or I certainly not going to see any value out of it for the next few years, or do I hire a contractor to build this thing for me? It's a really tough decision, but that's, first of all, pretty much entirely what the job of CEO ever is. And two, it's building a company. Startups are risk, right? That's all they are at the beginning. They're a bet you place that all the work you do will somehow be valuable down the line. And patents are exactly the same. It's if you believe that there's value here, you place a bet that it's going to be worth protecting and that you'll recoup the value down the line. So it doesn't make sense to me to be in the startup space thinking that way on your right hand, and not thinking about it when it comes to patents and legal.
So as patent agents and lawyers, we like to think that IP and all these agreements, these are the most important things, for any investor. But obviously, that's just part of it. They're looking at team and market size and all this other kind of stuff. So my question to you is, how important is it to investors, in your own experience, when they look at your patent portfolio and the IP that you have, do they value it as much as you do, or is it just, it's nice that they have it, or, like, what's their sense?
My sense of going through in the conversations, it's not, there's no one thing that pushes an investor over the edge, right? So you could have an amazing team and there's no market and there's no traction, they don't care. You could have, traction pretty much trumps most things generally. If you're growing at like gangbusters, you don't have any problems. But if you're like a more normal company and you have a lot of good pieces, one of those pieces is going to be IP, and IP does a few things. One, it is intrinsic value, right? It is a thing like your computers depreciate, but it is a thing that has value that can be resold. Without it, you just have ideas, and ideas without execution and traction don't really have value. So that gives them comfort that when they invest, there is intrinsic value they're investing in. But the second thing is, if you have a patent that's been, passed through some number of the hoops, and is close to being granted, or has actually been granted, it's actually validation on the idea, right? So you can point to these patents and go, we have built something net new, something that a patent house has evaluated and said there is novelty here, nobody else has done it, and it delivers value. It's not just frivolous.
Yeah. So Mo, went through, his experience, working with firms and lawyers and that kind of stuff. What has your experience been? What do you look for in a firm?
I think what I would look for in a firm is one that's going to be proactive on my behalf, right? And that's what I look for in an employee. There's too many things for me to do to be pushing every single box forward every day. And so, if you have a legal partnership, if you have a partnership with your legal firm that is helping you and sort of reaching out to you and pointing you to potential issues that are happening without you having to kind of sort of drive that conversation bit by bit every day, I think that's of most value to me. That and sound advice, obviously.
Yeah, absolutely.
But sound advice is kind of difficult as somebody who has no legal background. How do you judge sound advice, right? You have to trust your lawyer, and you trust your lawyer because he's given you sound advice in the past, and it's kind of this thing. So you got to start somewhere.
Okay. And now, when it comes to the agreements you should have at the beginning of this growth phase, you're a startup and you're looking to grow. Are there, like, I would say 5 must-have agreements you should have in place?
Sure. I think the shareholders agreement from the beginning, with a focus on the partnership that you and your co-founders have, right? I think an inevitability is when you raise money, your investor's going to come in and redo your shareholders agreement. So it only has to last you from day zero to that first equity round. So an effective shareholders agreement in the early days. Employment agreements that that cover all the bases, whether it's around the basics of NDA or the basics of IP ownership. But if they don't, then those two things: an NDA that you can use with your potential customers or clients that or targets, and IP ownership things that you can use with contractors and whatnot. I've lost count, but the last one would be a. What was the last one? I was just thinking about this question down there. Okay. It'll come back to me, and let's talk about something else, and then I'll say it randomly, and you'll know what I'm talking about.
So in terms of advice to these founders, when it comes to legal, what would be that one sentence that you impart to this group?
What?
Just one.
Crystallize. Just keep going, right? Like, if you believe it's there are so many things that will come up, and you'll be exhausted for weeks, and then something will come up and rejuvenate you. And if you had given up the night before, you wouldn't have gotten to the point that kind of something else came up and it rejuvenated you and allowed you to keep going. There'll be so many things that will get in the way, and may seem insurmountable for a period of time until they're not. And if you had stopped at any point in time, you would never have the opportunity to get around it and over it and keep going.
Okay. So in your journey, from you started in what, 2014?
Mm-hmm.
Yeah, 2014 to now. What one thing would you say has surprised you about yourself? being the CEO of this company and growing it and, you know, to where you are today?
I think, I mean, in sort of playing on that, the previous point about keep going, I found myself to be a lot more resilient than I would have thought, right? You kind of need to be tough and just, you take a beating and keep get up, you know, like Rocky. You know, just keep getting up and keep going. And that's his whole thing, was he just keeps getting up. And if you keep getting up, you'll eventually get there.
Okay, all right, fantastic. So listen, I really want to thank you for, you know, dropping by and, you know, talking to us. And, you know, you're always welcome here. So,
Okay.
you know, feel free to drop by anytime. And also, thank you very much.
Okay, thanks for having me.
All right. Okay. So we have about 20 minutes. So